We're going to get started. We're going to look at today's webinar, Wrongful Evictions, Recognizing Fair Housing Violations in, that underlie eviction filings and how to assert, preserve those fair housing claims. So first, the ground rules real quick. It's being recorded. Questions should go in the Q&A, not the chat, although I have both screens open, so I'll take a look at that. And this webinar provides general information, not legal advice. If you have more specific questions than that, please contact our office, Fair Housing Center, at 313-579-FAIR or info@fairhousingdetroit.org. Our website is also the same, fairhousingdetroit.org. For a second look, we will be placing this on our website under services and resources, also be posted on YouTube. I'll also put the PowerPoint on YouTube as well. There's another, for example, one that's kind of related to this on damages, and the PowerPoint is available there as well. And thanks again to MSHDA, Michigan State Housing Development Authority, for sponsoring this webinar. They sponsored several training sessions, and they've been just a great support for fair housing. Here's a kind of introduction and agenda. We're going to look at eviction filing rates and the causes of it, and we're going to explore common eviction cases that mask underlying fair housing violations. There's often fair housing violations that just sail right through eviction proceedings and never get raised. And briefly explore the major fair housing laws and enforcement, how they get enforced, standards for obtaining injunctive relief. That's the only way to stop an eviction, is to get injunctive relief, and recommended approach for raising and preserving fair housing claims in eviction context. First off, what are the eviction filing rate and what causes it? There's a National Low Income Housing Coalition has done reports for a number of years. And this one is March 2023. It's the most recent one. I think there's another one coming out, but it's in draft form. So I didn't want to put it on in the webinar with a bunch of draft language on it. But if you look at it, shortage of affordable homes, it's fairly significant. Right. And then we're really going to focus on, well, the area of median income is the median family income in the metropolitan or non-metropolitan area. But the focus is going to be extremely low income, ELI households, where incomes are at or below the federal poverty guidelines, or 30% of the area median income, whichever is higher. If you look at it, the summary here is extremely low income households account for 1/4 or 11 million of the nation's 44.1 million renter households. Now, the standard definition is that affordability, households should not be paying no more than 30% of their income on housing. For this 11 million people or households at the extremely low income levels, only 7 million units are affordable to this segment of the population. So it's a shortage of 4 million affordable rental homes. This is the only group that faces this absolute shortage like this. And here, this kind of shows it, maybe a little bit counterintuitive at first to look at. So at the bottom, the lower left, it's got 11 million households who can afford to live in, you see, for at their affordability level, there's only 7 million units in the US. And then if you look at 6.8 million households that are in the very low income, they actually, for that income level, there's 16.2 million units. So you can see much more available of a bit higher availability of units for very low income. And you go all the way up. By the time you get up to the top, the above median income, 12.5 million households are above the median income level. They can afford 46 million rental units. So you can see the only group that can't, there's an absolute huge shortage, is when you're looking at people that are at the extremely low income levels. And this shows it by state. I would like to say it's getting better, but this comes out each year and it's getting worse, actually. You can see by state, some states are really critical. States that you may not think of it, right? You wouldn't think Florida, Texas, California, right? New York is low. These are major states. Michigan here is 36. These are the number of affordable rental homes per 100 extremely low income renter households. And you can see that's very, very low. And this shows it in numerical amounts. You can see some of these are so high. Look at them. Again, Michigan is at 36, but Arizona only 24 units per 100 extremely low income families. And so we get complaints like this, people complaining about habitability. I stopped asking why, because people go into homes that are not habitable, the repairs haven't been done because they have no other place to live. Or another example would be people end up going through the eviction process, and where do they end up? Homeless, because they can't afford a place. There aren't places where they can rent, and the rent prices in most communities are just simply going up. Even more rental homes are becoming unaffordable. And you can see the relative supply of affordable homes increases with income. Extremely low income, there's only 33 rental units for every 100 renter households. And you see as you go up, it gets higher. It's not the same crisis at the higher income levels. And you would think, okay, the very, very low, extremely low income families, well, they're not working, or they've put themselves in this situation. They've made life mistakes, bad decisions in their life or whatever. But this kind of paints a kind of a different view on this. If you look at it, these are extremely low income renter households, and these are the demographics of this household. 35% of over a third are in the labor force. They're working poor, but they're still at extremely low income levels. 39% within the labor force, 39% are working 40 plus or more hours. 30% are 20 to 39 hours. Many are senior citizens within this group, 30%, and another community is 18% are disabled. So you can see, right? It's a group that we should be concerned about. And, we're a fair housing center. Obviously, we deal with discrimination. Is there a racial component to this? Yes, unfortunately. Just not going to look at all of these, but on the left side is Black non-Latino households, and on the right, white non-Latino households. The blue part is home ownership. And you can see the Black non-Latino families, 43% have home ownership. Within the white non-Latino households, 73% have owned their own home. So they're homeowners. So the percentage of rental households in the Black community is 57% compared to just 27% for white households. Now, if you take within that rental subset, 19% of those in the Black non-Latino community are renter households and are extremely low income, compared to just 6% of extremely low income renters within the white community. Where you can see, so there is a racial component, right, to evictions or families that are extremely low income. Sometimes it can be hard to separate out. Sometimes a lot of the focus is on race. And whereas I think there's a really intersection between race and social class. So low income families. But you can see whatever is done to address the problem of the lack of affordable households or affordable rental homes for extremely low income families, you will benefit minority populations without a doubt. Anything that can be done to kind of halt eviction filing rates and eviction rates will have a factor on this. So what are the results of a lack of affordable housing? What happens? Right? What do you think happens with it? Right? I would say what? Right? It leads to housing insecurity. There's two big thresholds of housing insecurity. One is where affordability reaches 22% and 32% thresholds. 22% means that 22% of the family's gross income is going toward housing expenses. So there starts to be an uptick in eviction filings at 22%, and it really significantly increases at the 32% threshold. And again, the extremely low income families go way above the 32%, 33% threshold of percentage of income that is being put toward housing expenses. Michigan did a big study of eviction by counties, eviction filing rates. And you can see by counties, some counties, believe it or not, the eviction filing rate annually per 100 residents. This is not over a 5-year period. The study was over a 5-year period. These are annual eviction filing rates. In some communities, it was 18.4% to 25.7%. So there was basically an eviction case filed against up to one quarter of the families. This shows nationally. At Desmond did a thing, eviction project. Nationally, 1 in 17 households, approximately 6 to 7%. In Michigan, 1 in 6, approximately 17% of the rental households have an eviction case filed against them each year. By counties, Genesee, 27%, Macomb County, 24%. This is just incredible. And the medium and large cities, Romulus, 47%, Inkster, 38%, Taylor, 37%. People think, oh, that's just Detroit. That's just a low income community, but actually poverty and eviction filing spread throughout communities. It's just stunning. This is absolutely stunning. It is certainly a crisis. This study also found that civil rights, fair housing violations, or protected class categories underlie many of the eviction filings. In the report noted that variables that bear a statistically significant, meaning that the 95% confidence level or 0.05 level of significance correlated to the following: the percentage, it's more likely to have an eviction filing against a renter household if the household is occupied by Black families, single mothers, family with children. So you can see there's a connection between eviction filings and eviction filing rates and protected class categories. And risk of eviction, right? Black households more likely to be at risk of eviction. This is a 2017 study. 11.9% of Black households face an eviction threat compared to just 5.4% of white families, right? And even Black families made up of, residents that have a 4-year degree, right? It's still a disparity, 6% to 3%. Least educated segments of the population more likely to be threatened with eviction. Families with children. This is really sad because children need stability for education, right? And but they don't. Families with children almost twice as likely to report difficulty with paying rent. Many times there's a lack of legal representation, and there's been quite a bit of work done with that, right, to counsel in eviction cases. So it is a crisis. And the sad part is without, as education levels increase, you still see disparities in eviction filing rates. So there is a clear connection between race and evictions. Younger adults, still, they report problems as well when they go to search for housing. So I'm just doing that to explore that there is a problem, there is a need, there is a connection between eviction filing rates and protected class categories, race, families with children, women, and there's others, and we'll get into those in just a second. So what are the common eviction cases that mask underlying fair housing violations? Well, first off, right, typically they're not raised or identified in summary proceedings or unlawful detainer actions. There's various phraseology or in the court rules of the various states. In Michigan, there's summary proceedings. In other states, they have different kind of language for the eviction process. But those hearings, and I call it eviction court, generally focus on the grounds set forth in the notice to quit, demand for possession, or in the eviction complaint. And counsel for housing providers rarely, if ever, are aware of the underlying housing discrimination. Certainly landlords, housing providers aren't going to tell their attorney, oh, we're discriminating. No, they'll just say, hey, file this case for us, please move forward with eviction. Then when the hearing occurs, tenants are not asked why they believe the real reason why they're being evicted. And I've seen this, even the few tenants that have counsel, could be legal services or private counsel, which is very rare, but they're not asked. And they're not even asked by the court. Well, what do you think is really underlying this? Why do you really think they're moving to evict? And just a simple question like that could reveal so much. As a result, few fair housing claims that are raised during eviction proceedings, and even those that do raise, encounter procedural barriers. But the key point I want to mention is this: tenants should be asked, what do you think the real reason is? Why do they no longer want you to live here? You got to ask that question, right? And you get quite a few different answers. And I can, start on the bottom left and work through non-renewal of tenancy. They won't, if it's discrimination, often they won't give a reason. Well, we're just non-renewing. That's what they'll say. We'll just non-renew. Why are you non-renewing? Well, I don't know. We had someone, complaint came in yesterday. Well, it kind of gets into motion support and service animals, but the same idea. The tenant was told to go into the office and sign, then basically the lease was ready and to sign the lease and remain in the unit for another year, like basically another 1 year renewal of the lease. Well, the tenant walked in with a certification for an emotional support animal. And he said, well, I don't know, we got to look at it. So he was not given an opportunity to sign the lease. So then she went back to her unit and then received a non-renewal. That kind of a thing. Typically, there are no quote unquote non-renewals. Non-renewal, they don't give a reason why they're not going to continue with the tenancy or to give the 30-day notice or whatever notice is required to terminate a tenancy. So they don't have to. The problem is there is a reason. There is a reason. Maybe the property is being sold to someone else. That's one thing. Or, I was renting one time, and the landlord wanted a family member to come live in the unit, so we had to go. Right. But that's a kind of a legitimate reason. But many times they mask reasons that are just wrong. But it's shrouded, covered up in a notice of a non-renewal without any reason being given. And that's why many local cities, municipalities are having just cause, requiring landlords to give a reason why they're non-renewing. There could be evictions for one or more rule violations. No problem with that, except that what? The rule violations should be applied fairly. It shouldn't be, holding a strict standard. You're being evicted because there's personal property on the porch at a mobile home park or around your mobile home, whereas other persons have, like a family may have bikes and tricycles and things like that. And then you look across the road there, and at the mobile home park, another tenant has barbecue equipment, sports equipment, whatever, but they're not being told that that they're being evicted because of rule violations, that kind of a thing. There can be a violation of quid pro quo or sexual harassment, where someone then is, because they refuse to acquiesce in sexual advances, refuse to date the landlord. We'll see an example of that they're then forced to leave. There could be domestic violence situations where victims are being evicted because of domestic violence. That will have an adverse impact on women because they tend to be disproportionately, well, I don't know what the percentages are, roughly in the 80-some% victims of domestic violence. If someone is evicted because of domestic violence, that'll have an adverse impact on women, families, rental household headed by women. There's obviously, we're going to see an example of that, emotional support animals and service animals. As soon as that gets raised, that someone may say, oh, you know what, we don't want to continue with the tenancy. There could be enforcement on the number of occupants. If two parents, have a child, an infant comes into the unit, they can be required to either move into a 2-bedroom unit or be evicted. And that can be unlawful because that can have an adverse impact on families with children. It's another grounds why people can be evicted. And eviction can target disabled or other minority groups. It's really sad to say. Sometimes, people that have disabilities, often landlords, housing providers really do not want to continue to rent to them. And because, well, various reasons, but you get the point. So many of the eviction cases have underlying fair housing violations. I'm going to go through and just give 4 of them and then go into some of the laws and some of the things that can be do to counter this. First time, it's a FaceTime case. It's a race discrimination case. And this came from the agent for the landlord saying, this is the number to, I obviously deleted that. I blocked it out to FaceTime the landlord. So what happened is the tenants were approved. They had very high income. One of the tenants worked at an auto company, quite a bit of income, making around $100,000 a year. Wife was a psychologist. She was making about $200,000 a year, well above whatever they would need to pay for the rent. It was a very fluent neighborhood. They passed on the credit and rental history. The tenants and the landlords were represented by real estate agents. The tenants agent, they paid a security deposit. The tenants and the tenants agent signed the lease. The landlord's agent approved, signed the lease. They paid the security deposit in the first month's rent. They received keys and moved into the home, and with the understanding that the landlord's signing of the lease was just a mere formality. However, later that evening, after they already moved in, got utilities in their name and everything else like that, the landlord said, well, I have to FaceTime the tenants. And unfortunately, then the landlord refused to sign the lease, then had his attorney file immediate eviction against the tenants as trespassers. So you can see some of the text messages here. He was glad I got to meet so-and-so and her husband. I like them very much. We are good with everything. This came from the agent, the real estate agent for the landlord, and the real estate agent for the tenants. Okay, great, perfect. I'll send you a copy at least later today. My client wants to know if you want to meet this evening instead of in the morning, let me know. Works fine. So everything is being set up, right? The clients being the tenants, we're ready to meet, sign the lease. Okay, all that got done. Then suddenly a request came through 11:12 p.m. This is the number to FaceTime, or please provide his number and she can call him. The landlord was in San Francisco. The couple was in Michigan. So there was a time change, obviously. So then the owner then says, the owner would like to see copies of IDs and 2 recent pay stubs. This will complete our file. Thank you. Right. So they needed to see IDs, like that was important, or that hadn't been done. Everything had been approved. They had everything. They had been evaluated in that. Then suddenly the owner has some concerns. And then what happened? Right. You can see here you text me last night that you and him were fine with everything. Yes, but the landlord did not sign the lease. And then basically said, you have to get out. You basically have to get out or I will call the police. Not amazing. The owner said, stop. What? And reason is you don't have a signed lease. The owner said, stop. Give me his number so she can talk and explain it to him. They had the mover scheduled, right? Basically tell them to stop moving in. Then the landlord's agent finally wrote and said, I do want to apologize to your client. I'm sorry for the situation they're in. I'm sorry for things working out this way. I'm sorry if this made them feel like criminals. I'm sorry they feel I bargained in bad faith. I'm sorry I did not wait till everything was cleared and the landlord signed the lease. The thing is, I was doing my best to get them into this home. They were doing the best to get them into the home till the landlord started to, discriminate. And so this is what got filed in court. The plaintiff has a right to possess. Forcible entry was made, and you can see D is checked. Defendant was a trespasser, and you can see handwritten on the first page. Plaintiff seeks immediate possession upon entry of judgment, and there's a trespass complaint, meaning as soon as the court hearing is, the tenants have to be out immediately, and all based on the fact that the landlord refused to sign the lease after FaceTiming, the tenants or prospective tenants, right? And then said, basically, you got to get police were called to the site, but refused to become involved. Obviously, they didn't, because police wouldn't get involved because the tenants had a lease. The only thing it didn't have was a signature by the landlord, but it certainly had a signature by the agents. Both agents signed and the tenant signed. Here's another, again, there's 4 situations, assault and battery case. Black family, white family. On March 5th, the high school student, this was a junior black student, junior in high school. As she got off the bus, she was assaulted by a white sophomore, the white sophomore's mother, the white sophomore's aunt, the sister of the mother, 3-on-1. Immediately, the mobile home park sprung into action, took statements from the white family, took no statements from the black family at all. 2 days later, they did a 7-day notice to evict the black family. No action taken against the white family. The eviction complaint got filed March 24th. On June 6th, there was an investigation against the white family, the mother and the daughter, the sophomore and the mother, for assault and battery. Prosecutor's office issues assault and battery charges. Nothing gets done by the mobile home park against the white family. On July 8th, got involved, filed a fair housing claims in circuit court, and moved to enjoin the eviction. There was an eviction case filed finally against a white family, but it just sat. They never really pursued it. On July 22nd, the mobile home park dismissed the eviction case without prejudice, and all the claims were dismissed in July. That would have been the end of it. But because of the delay, monitoring this case, right, in September, the mother found juvenile court, they acquitted, they didn't find the daughter, the sophomore, guilty of assault and battery. But in September, found the mother guilty of assault and battery. November 6th was the sentencing. And then November 18th, a consent judgment was entered, permitting the mother and the family to remain until December 1st. They didn't move out until December 1st. At that point, seeing the different treatment of the white family in comparison to, even after an adjudication of an assault and battery conviction, they still held off till after sentencing. So then I refiled the case in federal court for fair housing violation, right? Again, you can see immediate moving to evict, one family taking no action against the other, even though the white family were the perpetrators. Another eviction type case, this is quid pro quo sexual harassment. These are the kind of statements that the landlord was making to the tenant, wanting to run his fingers through her hair, and you can get the idea. I'm not going to read this. But it absolutely frightened the tenant. She was, I think, 2 years older than him, so they were pretty close in age. But she wrote this on her Facebook page: "I think I'm going to be kidnapped and locked in someone's basement. This guy don't quit. Something seriously wrong with him. I don't know how many more ways I can tell him no." And this went on for about a year and a half. And she said, "Look, if I show up and I'm not missing, basically check the landlord's basement," right? Absolute fear and dread of living in that unit. Sorry about that. So what happened is this. Because of work situation and that was kind of a layoff on the job. She got behind on the rent. The landlord moved to evict. They went into court, and then they made an agreement for her to catch up on the rent payments. That was fine, right? And as they walked out toward their car, the landlord put flowers on her car. All right. So continued to stay there, and she was working to catch up on the rent and that. So then there was a 4th of July came, where the landlord saw a gentleman coming out of her rental unit. At that point, the landlord said, "You know what? I think he realized he did not have a future with her. He didn't have a present with her either, but he realized that he didn't have a future with her." So that same day, he goes back to his home and he sends this message. He says, "I don't want to be your landlord anymore. I'm quitting. I want a better life for myself. I'm selling the house and the land, and I'm moving back to Molly." That's the street there. "You can't make me rent to you." This actually turned out to be false. He never really sold the house, never sold the land, right? So what had happened is, once he realized he was not going to be able to have a relationship with her, he no longer wanted to continue with her being his tenant. Another situation is eviction due to an assistance animal or emotional support animal. And you can see the pit bull reference in your letter must go. Here's kind of the script or the certification. She suffers from generalized anxiety, panic attacks, and severe insomnia. At my recommendation, she has a service dog, should be really assistance, emotional support animal. Her dog has allowed her to control her anxiety, prevent panic attacks, and helps her sleep at night. So this was the rules, animal rules and regulations. You can see number 2 has a weight restriction, 15 pounds, and they have breed restrictions, specifically prohibited German Shepherd, Collies, Dobermans, Great Danes, and for purposes of this case, pit bulls, right? And the landlord, I guess, there'd been some contact with the insurance company, and the insurance company says, if a community allows pets, we expect the community to have a formal and restrictive pet policy. And you can see they list, again, all the restrictive breeds, including pit bulls, right? And any exotic pets also, there's a restriction on that. So basically, if the landlord, housing provider, does not have this kind of restrictive policy, the insurance company will cancel their policy. And this is what they said. So they made the request for the emotional support animal, and this was the answer written by the landlord. Basically, accommodation unreasonable, impose undue financial administrative burden. If a housing provider's insurance carrier would cancel, substantially increase insurance policy or change it, how to find this poses an undue financial administrative burden. Based on the above, the pit bull reference in your letter must go. So they had to kick, and they then filed, gave a notice to evict, and you can see violation of community rules and regulations, prohibited breed must be removed from the community. She didn't fight this. She removed the dog from the unit. So we're going to come back to these 4 situations and see how we address them. First thing, what are the major fair housing laws and the means to enforce it? The main ones, federally, Fair Housing Act. You can see the protected class categories on the right: race, color, national origin, religion, sex, familial status, and disability. Section 1981. This 1981 deals with contract rights. People have the same, they have the right to have a contract. You can't be discriminated against in your contract on race, color, ancestry, and alienage status. Section 1981 covers or gives protection for non-citizens. So it's a little bit broader than Section 1982. Fair Housing Act also protects any person, doesn't matter about citizenship status. So 1981 deals with contract rights. A lease is a contract. Mortgage is a contract. Even employment is a contract. So it's covered under, if there's any discrimination under Section 1981, that's discrimination on grounds of a contract. It protects all persons. Section 1982 kind of overlaps with 1981, but it covers property rights. We'll see that in a second. And you have to be a citizen under Section 1982, and it covers race, color, and ancestry. Section 504 and the ADA deal with disability. So those are the main federal protected classes. You can see 1982 property rights. All citizens of the United States have the same right in every state and territory as enjoyed by white citizens to inherit, purchase, lease, sell, hold, and convey real and personal property. And by the way, when it says enjoyed by white persons can bring a race discrimination claim under 1982 or under Section 1981. And Section 1981 has contract rights. All persons, not citizens, all persons. So it covers people regardless of immigration status, have the same right in every state and territory to make and enforce contracts. And make and enforce contracts includes making, performance, modification, and termination of contracts. So these are bedrock. There are no exceptions to these 2 laws. No Miss Murphy, no single family. It applies without any exemption. Then the state protected classes, I'm using Michigan's, most people are probably from Michigan. Now up to 10 categories: religion, race, color, national origin, age, sex, sexual orientation, gender identity and expression, familial status, and marital status. I've got highlighted the additional categories that are not found under the federal laws or Federal Fair Housing Act. And Michigan Persons with Disability Civil Rights Act covers disability. And there's also local ordinances as well. Those are protected classes. What's discrimination based on a protected class? It's taking someone's protected class into consideration in making an adverse decision to eliminate or terminate, and eviction obviously is a termination of housing. So here's the key thing. What are the enforcement options? Well, there's court is an enforcement option for pursuing a fair housing complaint. And there's administrative complaint, HUD, and state and local civil rights agencies. Unlike employment law, there's dual enforcement when it comes to fair housing. Someone can file and proceed with fair housing claims, both in court and administrative proceedings simultaneously until trial or hearing commences an administrative proceeding, either in HUD or your state agency, or trial commences in court. Then the other claim will have to be dismissed. But until that time occurs, both can proceed simultaneously. So how are the complaint process and how they really work? Just real briefly, there's 1 year to file with HUD. State and local civil rights agencies vary from 180 days to 1 year. In Michigan, it's 180 days. There's overlapping coverage. For example, within the period that the state or local agency will receive complaints. So Michigan Department of Civil Rights, it's 180 days. There's overlapping coverage with HUD. If it's a substantially certified as substantially equivalent agency, HUD, within the first 180 days, if it receives a complaint that's within the jurisdiction or locality of the state and local agency, it will refer the complaint to the state and local agency for all further processing. After the 180 day up to 1 year, then the complaint will solely be with HUD. And again, like for example, if it's a age discrimination complaint, it's not going to go to HUD because HUD doesn't have jurisdiction over age discrimination. HUD is limited to the 7 protected class categories under the Fair Housing Act. But if there is an overlap, for example, like race, color, national origin, disability, then within the first 180 days, HUD will send it over to the Michigan Department of Civil Rights. Now, there can be other laws, like, for example, Section 504, state agencies do not have jurisdiction over Section 504. That will only be handled by HUD. I won't go into too much detail with it, but just to know that there's these options. The court action, there's 2 years to bring a claim under the Fair Housing Act. The 2-year period is told during the time that administrative complaint is pending. You don't need to file with HUD or a state agency before filing in court. Now, for 1981, 1982, the limitations period vary. It's based on, according to the Supreme Court, it's based on the state statute of limitations for a state for personal injury actions. Some states 1 year, 2 years. Our Michigan is 3 years. Some states 4 or even more. It depends. State civil rights laws also vary in terms of their limitation period. Department of Justice, there's a 3-year period from the time the Department of Justice learns of the case. If they seek only injunctive relief, there is no time limitation for when the Department of Justice can bring the case, but they only get involved directly when there's a pattern and practice of discrimination, that meaning involving multiple victims. Department of Justice can also get involved in election cases, and that's where, for example, HUD is processing it, HUD finds cause, then the case gets filed as, cause gets filed before the Office of Administrative Law Judges, and parties have 30 days to make the election to have the case heard in court. Then the Department of Justice will then step in, file the case in federal district court, and HUD will be out. And then it'll be the United States versus who the respondent is, and they'll bring the claim on behalf of the aggrieved person. So real quick, what's the role of the Fair Housing Center in these types of claims or eviction cases? There's coverage for every county in Michigan. Most states have coverage. Not all of them, though. There's some states where there isn't really coverage. But Fair Housing Centers are an advocacy organization. They're nonprofit, but they assist. They're supposed to be advocacy. And there's no jurisdictional limits. Like HUD is limited to the Fair Housing Act and certain laws, civil rights laws pertaining to federal financial assistance. Michigan Department of Civil Rights, for example, is limited to state civil rights laws. Fair Housing Centers are not. We can do all the civil rights laws. We can do, in addition to that, landlord-tenant type issues, security deposits, lockouts, all kinds of different laws to provide. And we'll handle all of them simultaneously. The other thing that's real important that a fair housing center can do is conduct testing depending on the complaint. It can help corroborate claims, get evidence to show a violation, and can come alongside and assist the person who's been the victim deciding whether they should file with HUD or state agency and Michigan Department of Civil Rights or going to court. We also keep a list of independent cooperating attorneys that can represent persons on a contingency basis, either administratively or more often filing a case in federal or state court. So what are the administrative agencies, right? Administrative agencies, they receive complaints, they look to find cause, and they can award recovery such as damages, economic damages, non-economic damage like emotional distress damages, civil penalties. They can seek injunctive relief and attorney fees. In court action, you can see the main thing about court action is that there's availability of punitive damages. You can't get punitive damages in administrative actions. So that's the main thing, the reason why to go into court. So again, I can't, because what's the role of your fair housing center? Well, we assist people in going through the administrative process. So HUD can enforce fair housing laws, Department of Justice, like I said, in pattern and practice cases or election cases. Then there's state and local agencies can receive complaints, investigate them, and then move forward with administrative hearings if they find cause to believe discrimination has occurred or is about to occur. And private persons. And person under the Fair Housing Act is defined, you can see it's so broad, one or more individuals, corporations, partnerships, associations, labor organizations, municipalities. It can be persons as well. So basically anybody can bring a fair housing claim, but we assist. And we do so because it's a HUD regulation, right? Fair Housing Enforcement Organization means what? Receive complaint intake, complaint investigation, and testing for fair housing violations and enforcement of meritorious claims. And so that's what the fair housing centers do. We should be your good first step if you have a fair housing claim. Even a non-fair housing claim, contact us, see if there's something that we can do to assist you. Otherwise, it's a complicated process. You don't want to run the risk, especially in an eviction case, of losing the claim because you're not aware of what the enforcement mechanism or procedure is and what the best way is to investigate it. So what are the standards for obtaining injunctive relief? How can you halt the eviction? Well, first off, injunctive relief is available under all fair housing statutes. In the Fair Housing Act, it's right in the statute itself, 42 United States Code, section 3613C1. Under sections 1981, 1982, actually, there's no provision in the law or in the statute for injunctive relief. However, the Supreme Court in Johnson versus Railway Express Agency and Jones versus Alfred Mayer said that you can get injunctive relief under sections 1981, 1982. At the state level, I have ours listed here. Our Person with Disability Civil Rights Act and Larson Civil Rights Act provide for injunctive relief. In administrative proceedings, I have the citation there. HUD can seek injunctive relief as well. And each state and local agency that enforces substantially equivalent fair housing law must provide for injunctive relief. And I have the citation there for the Michigan Civil Rights Commission, their right to seek appropriate temporary relief, meaning injunctive relief. The problem, though, however, is that HUD and state and local civil rights agencies rarely seek injunctive relief. You can't count on them doing so. So these are some of the factors to be considered in seeking injunctive relief: immediate threat of injury, loss, or damages. Maybe the property is unique, depending on the likelihood that irreparable injury, loss, or damage will occur unless injunctive relief is granted. The likelihood the person will succeed on the merits of their fair housing claim. And is the dwelling still available? If the dwelling is now occupied by someone as a good faith purchaser or a renter without knowledge of the underlying discrimination, you can't force them out. That can't happen. But sometimes the dwelling continues to be available. And often, question is whether the victim really wants to be in the home. If they do, then it could be good grounds for seeking injunctive relief. So what are the elements for injunctive relief? Generally 4: likelihood of success, likelihood of establishing irreparable harm, the balance of equities tipping in favor of the person seeking injunctive relief, and determination whether that the injunction is in the public interest. What I found is about half the cases get the standard right, about the other half of it don't. The key factor is likelihood of success on the merits. It's readily met in some cases. For example, there could be direct evidence, an email, text message, statement made, could be testing evidence, right? So making clear, hey, there is liability here. In other cases, a little bit more difficult to establish unless there's further investigation or discovery. Reparable injury, it's kind of surprising. Sometimes I don't even see this cited. Like, well, you haven't proven irreparable injury. You don't have to prove it. Due to national policy against race discrimination in housing, irreparable injury is presumed once a plaintiff has demonstrated the likelihood of success on the merits of their fair housing claim. And these are the citations for that. So irreparable injury should not be a concern. Again, this not only applies to fair housing, it applies to civil rights claims generally. If there's irreparable injury gets assumed because of national policy against discrimination, once there's been a good showing of likelihood of success on the merits. So, let me see here. So balance of equities is a third factor. In most cases, a plaintiff will clearly suffer preliminary harm if relief is not granted and the defendant is permitted to sell or lease to a third party, right? In one fair housing case, court found a balance of equities to favor granting the injunction where the plaintiff was current on rent escrow payments. Plaintiffs are paying rent, so defendants cannot claim any harm suffered as a result of the arrearage. Then the fourth factor is harm to the public interest if the injunction is not issued, and there will be harm to the public interest because of the policy underlying the Fair Housing Act and the policy underlying sections 1981, 1982. Right? What is the public policy? Right in the Fair Housing Act, this is the policy of the United States to provide within constitutional limitations for fair housing throughout the United States. HUD policy in implementing the discriminatory effect standard 2013 said the Fair Housing Act was enacted to combat and prevent discrimination, segregation, and discrimination in housing, including the sale, run of housing, and the provision of advertising, lending, and brokerage services related to housing. And the Supreme Court has recognized this. I like the Trafficante quote: eradication housing discrimination vindicates a policy Congress considered to be of the highest priority. That really puts it here. Jones versus Alfred Mayer. Clearly, the act was designed to do just what its term suggests, to prohibit all racial discrimination, whether or not under color of law, with respect to the rights enumerated therein, including the right to purchase or lease property. So, right, come back to it. Likelihood of success on the merits seems to be really only the real determining one. 2, 3, and 4 tend to not be problems, right? Someone will probably suffer some type of harm, irreparable harm, right? It's presumed when it comes to a civil rights violation, as well as injunction is in the public interest, and the balance of equities provided, that someone is current or is not committing rule violations, things of that nature, that typically the balance of interest will favor in favor of the tenant seeking injunctive relief. Here's a couple things to be noted. Harm to the public interest if the injunction is not issued. Edward Rosenson's case, where there's been a showing of housing discrimination, preliminary injunctive relief serves the public interest by carrying out the stated policy of the United States. Right? So there's case law for that. A couple of notes: it's a threat of eviction, not the actual eviction. You don't have to wait till the case is filed in court. If they do anything, issue a notice or something where they're going to be threatening eviction, that's a violation. If anybody doesn't think so, just talk to people who have under the threat of eviction. That's frightening, right? Losing their home. That's real basic to someone. Also, if there's a violation shown of 1981, it will establish liability under 1982 in the Fair Housing Act. So you prove a Fair Housing Act violation if it's a protected class category that also applies under Section 1981, 1982, it's going to establish liability. Same way with any state, local civil rights laws. So a violation of one statute will probably be held to violate the others. Courts generally don't use inconsistent standards in determining liability for civil rights violations. They'll apply the same standard throughout. The only exception would be Sections 1981, 1982 has to be intentional discrimination, You cannot bring a disparate impact case under sections 1981, 1982. You can bring it under the Fair Housing Act and state and local laws typically. All right, so here get to the heart of it. Recommendation for raising and preserving fair housing claims in eviction context. And these are critically important strategic and procedural considerations. Does the Fair Housing Act claims really get addressed on the merits? And should you choose federal court, state court, or an administrative complaint? Well, here's the problem with federal court. There's four major impediments: the Anti-Injunction Act, Rooker-Feldman Doctrine, Younger Abstention, Res Judicata, and Collateral Estoppel. So here's a recent case out of California. There's a whole bunch of them. Full Faith and Credit Act directs all courts to treat a state court judgment with the same respect that it would receive in the courts of the rendering state. So federal courts have to give full faith and credit and give collateral estoppel and res judicata effects to the effects of the judgments of state courts the same way the state court will treat the judgment. So the Anti-Injunction Act, I'm not going to go through all the citations here, but basically says, according to the United States, federal district court, or even court of appeals, but typically federal district court will not grant an injunction to stay proceedings in a state court except as expressly authorized by an act of Congress or necessary in aid of its jurisdiction or to protect or effectuate its judgments, right? Typically, right, you could say especially authorized by an act of Congress. That really won't work because the Fair Housing Act is enforceable both in state and federal court. So the express provision authorizing such an order doesn't really apply or necessary in aid of its jurisdiction, right? Typically, that doesn't apply as well. The district court does not have exclusive jurisdiction unless the case has been removed from state court. Typically, eviction cases are not, because eviction cases don't have a federal claim. So you don't get it. And there are plenty of cases where someone has defendant or tenant has tried to remove an eviction case into federal court, and the federal court send it right back. So that doesn't work. Perfect or effectuate its judgment typically doesn't apply. There isn't any federal court judgment. There's an ongoing state eviction proceeding. That's not a federal court judgment. So the Anti-Injunction Act generally will apply. Rooker-Feldman, it says that a federal court doesn't have jurisdiction to review a case litigated in the state court system. Only the United States Supreme Court can act into correct state court judgment, basically meaning the eviction case has to appeal through the state court system to the highest court in the state, and then the appeal goes from the highest court in the state to the U.S. Supreme Court. And I don't need to tell you how often that occurs, like zero, right? It doesn't really occur. So federal court claim, a claim would be barred by Rooker-Feldman if the federal claim was actually litigated in the state court, or if the federal claim is inextricably intertwined with the state adjudication, right? So basically, Rooker-Feldman is a major impediment as well to it. Some courts do a more narrow approach to Rooker-Feldman. Perhaps I still think this is a major barrier without getting too much detail. I just want to alert it and not do exhaustive research on it in this webinar. But Rooker-Feldman is a barrier. Younger abstention is another factor as well. Federal courts decline to interfere with pending state or civil proceedings when important state interests are involved, right? And the challenge state proceedings currently pending involve important state interests and afford the plaintiff an adequate opportunity to raise constitutional claims, even raise fair housing claims. So what they will do often is they will, for younger abstention, or they'll just abstain. For example, there was a case where there was, it's a recent case. The tenant wanted to file fair housing claims in the eviction case. The judge in the eviction case would not let the plaintiff do so. So then the plaintiff filed a complaint in federal court raising the fair housing claims. As it turned out, I think there was an appeal also from the state eviction case, and basically said the state court judge was wrong, that the fair housing claims could be raised in the eviction proceedings. So what the federal district court said, put the case on hold in federal court, abstained until such time as the fair housing claims have been adjudicated during the state court eviction process. So again, younger abstention is going to say federal court says, if you want to raise those things, do that in state court. Res judicata, collateral estoppel, major barrier as well. Meaning once there's been a decision on the merits, you see this recent case out of Kentucky, decision on the merits, enforceable detainer action in state court given res judicata effect as to later federal court action under the Fair Housing Act. Meaning they could have raised the fair housing claims in the enforceable detainer action, right? And so therefore it should have been raised there. The decision in the state court means it's collateral estoppel, res judicata. Res judicata is claim preclusion. Collateral estoppel is issue preclusion. But if you raise it in the state court eviction process, then you will be barred from raising it later. You can see down there, Hughes versus Deerpath, Fair Housing Act claim barred under res judicata, even though it was not raised in the state court proceeding, meaning that's something that could have been raised. I think that's old law. They've now kind of corrected that in the Michigan statute. So it varies as to how strong courts will recognize them, but it still is a major impediment. And here's the change in the Michigan law, which kind of scaled back on the res judicata collateral estoppel effect. Basically, it says that a party is not required to bring claims in the eviction proceeding. They can then hold off, file those in a separate court case. So here's the key, what I'll leave you with. How should it be handled? So we're going to look at the federal forum, federal district court, trial court for the eviction unlawful detainer action, and then HUD and administrative proceedings. So the first thing is this. Federal district court, the four impediments we mentioned: Anti-Injunction Act, Rooker-Feldman Doctrine, younger abstention, and then res judicata and collateral estoppel. Only two reasons to file in state court. First, and here's the most common one: state court eviction unlawful detainer action has not yet been commenced, and you can obtain injunctive relief before the state court eviction unlawful detainer action is filed. You got to beat the landlord into court, file in federal court, get an injunction, and do all of that before the state court case is filed. If the eviction court unlawful detainer action, eviction complaint is filed, you pretty much cannot obtain injunctive relief in federal court. Your only option is to try to seek injunctive relief in state court. A second and less common approach, I have used this one. You still file your fair housing claims in federal court because federal court's generally more favorable forum for fair housing cases. The threat of damages may cause a landlord or housing provider to reconsider proceeding with the eviction or the unlawful detainer action, basically calling their bluff. Fine, you want to do it? Make the damages high by evicting someone because you violated civil rights laws. You violated fair housing laws in this eviction. A second form is trial court, where the eviction unlawful detainer action is filed. Landlord court, we'll just call it landlord court. The recommendation: do not file or assert fair housing claims in that eviction court, either as a defense, affirmative defense, or counterclaim. If, again, in all likelihood, you do have the right to assert fair housing claims as a defense, you have that right. But if you do, and it gets raised, and there is decision in favor of the landlord or housing provider, it's very likely result in res judicata or collateral estoppel of those fair housing claims or allegations being barred. Then you will not be able to raise the fair housing claims in another proceeding, either in a new state court action or in federal court or in another forum, an administrative proceeding. They can receive the complaint administrative proceeding, and then the agency and HUD can take action to address the discrimination, but there won't be anything for you in that process because your claims are done at that point once there's been a state eviction court decision. So again, the problem is what? Underlying fair housing claims or violations often not addressed as a proceeding focus on the landlord or housing provider's claim for eviction, right? If unsuccessful, raising non-fair housing defenses, like, well, there's no defense then. Well, you raise other non-fair housing defenses. Let's say you don't have any defenses other than the fair housing violation. I guess you lose at that point. But the answer is to come raise some kind of defense in order to appeal it to the higher court of general jurisdiction. So another forum is the court of general jurisdiction, meaning once the eviction or unlawful detainer action has been filed with the eviction court and federal court is no longer an option, the fair housing claim should be filed in the state court of general jurisdiction. In Michigan, it's circuit court, as circuit courts have exclusive jurisdiction of fair housing civil rights claims. All federal fair housing claims, whether it's Fair Housing Act, Section 1981, 1982, et cetera, may be filed in the court of general jurisdiction. So what you do then with that case filed in the court of general jurisdiction, then move for injunctive relief in the court of general jurisdiction. All state and federal civil rights statutes provide for injunctive relief. And again, due to national policy against discrimination, irreparable injury will be presumed. Harm to the public interest will be deemed established, right? In fair housing civil rights cases upon a showing of likelihood of success on the merits. So that's where you want to seek. Once the state court case is filed, eviction case is filed, then you have to go to your court of general jurisdiction, ask for injunctive relief. And just a heads up in interpreting or applying Fair Housing Act, other federal civil rights laws when it comes to housing, rely on HUD's regulations. There are 24 CFR Part 100, sections 100.1 to 100.600. There's a number of HUD DOJ policy statements and guidance that are very, very helpful as well. Another option as well is to file an administrative complaint with HUD or state and local civil rights agencies. They have authority, again, as we mentioned, to pursue injunctive preliminary relief, but they seldom do, and you don't expect them to. So why am I saying you still file with them? Because they would do a great deal of assistance. First, they'll inform the landlord or housing provider of the fair housing complaint, what the fair housing laws require, what shows as an unlawful housing practice under fair housing laws. And then they also informally, without exception, really, will request that the landlord housing provider hold back on the eviction until the investigation has gone through and there's been a cause determination. Now, to fail the landlord or housing provider to work with HUD or state civil rights agency to hold off on the eviction can be used as evidence later. It can also give grounds for punitive damages. So I'm saying this is, let's say, again, even make it even more direct. If you can file before the eviction case is filed in court, go into federal court if possible, get an injunction stopping the eviction. If that is too late, the eviction case has been filed, then file an answer from defenses, even a counter complaint in the eviction court, but do not raise fair housing claims. Do the fair housing claims in a court of general jurisdiction and ask for injunctive relief right there. If you're unsuccessful in the eviction unlawful detainer action, then that gets appealed as well to the court of general jurisdiction. The same court will have both cases. And they will take a hard look at the eviction and the fair housing violations all in one proceeding. That's a much more favorable forum. There's more likely to be more discovery and depositions and to do the fact gathering, discovery gathering that you need to really establish the claim. And also do not neglect using HUD, state and local civil rights agencies. They can assist you as well. So look at what you've got going on. The defendant is really, or the landlord, housing provider is seeking to evict someone. Now they're dealing with proceedings in eviction court, landlord court. They're dealing with it in a higher court of general jurisdiction, and they're dealing with an administrative complaint. So someone who's been a victim of housing discrimination in the eviction process is going to have a day in court. They're in 3 proceedings, but you want that. That's how you really protect their rights. So look at all the kind of things that can get filed. The answer to a complaint, affirmative defenses. You don't want to raise fair housing claims in those. A counter complaint can be filed, or, don't put fair housing claims in it unless you're going to have that removed to the court of general jurisdiction. Don't leave that sitting in the eviction case. You want to enter a motion for entry of an escrow order that deals with the balance of harm. The landlord cannot claim, the balance of harm is against the landlord because the rent will get paid. I will voluntarily submit an escrow order, make a jury demand. In any case, you want to have a jury demand heard, ask for discovery and propose discovery. That can be done in the eviction court. It certainly will be done in the court of more general jurisdiction. Do a brief in support of discovery. If you file the counter complaint, in the eviction court, make sure you do a motion to have that claim removed to the court of general jurisdiction, or just file the counter complaint as a separate complaint straight up in your court of general jurisdiction. Do a brief in support of it and a proof of service. That's a lot. It's a lot of pleadings, but it's very, very helpful. So let's go through, we're going to go through our 4 cases and see what happened with them. On the FaceTime case, race discrimination claims are filed against a landlord under sections 1981, 1982, the Fair Housing Act, and state civil rights statute. Case law supports the finding of a fair housing violation because a landlord housing provider may not inquire as to the race of the applicants. There's no legitimate reason to ask them for identity documents, right? When they already had that information, had already approved them, right? They wanted to see, the landlord wanted to see what race they were and to FaceTime them to see their race. Injunctive relief was available but not sought. The tenants decided to move to another home. Very unfortunate. They had a tragic killing of one of their sons and just did not want to proceed. But it was a disgusting case. Sadly, in a lot of home sales, sellers have cameras in their home, right? Agents kind of keep the buyers and sellers from having direct contact with each other, but now they have cameras in the home where they know full well who the buyers are, their race, ethnicity of the buyers. On the assault and battery case, again, this was occurred after what? 7, 8, 9 months where they hadn't taken action against the white family. So race discrimination claims are filed against the landlord under 1981 and 1982, the Fair Housing Act, Elliott Larson Civil Rights Act. There wasn't really direct case law. I thought there would be, but there wasn't. But there was liability and employment discrimination decisions where there were claimed rule violations and actions was taken against. Well, it was actually a flip side, but there was a McDonald, not McDonald Douglas, but a different McDonald case where there was an incident on the job and the employer immediately fired 2 white employees and did not fire a black employee for the exact same conduct. And that was what I used to argue the assault and battery case, where there was action immediately taken against the black family, but not the white family, even though, I mean, it was even stronger than the employment case, because here there was adjudication that the white family was at fault. I was shocked the circuit court denied injunctive relief. I didn't seek injunctive relief in federal court due to the Anti-Injunction Act and the other federal court barriers to relief. Once the whole state court proceedings were dismissed and the housing provider continued to delay to move to evict the white family, then I filed the case in federal court. Because the black family was allowed to live there, there was no need to seek injunctive relief. On the sexual harassment case, sex discrimination claims are filed in the Fair Housing Act and our state civil rights statute. Liability for quid pro quo. Quid pro quo is this for that. If you acquiesce in someone's sexual advances, you can remain in a unit. If you don't acquiesce, you can't stay. That's still part of quid pro quo sexual harassment. And liability was supported by HUD regulations. HUD has a good elements of proof memorandum, and by provisions of the Elliott Larson, our state civil rights statute, has very good provisions on sexual harassment. The tenant, however, vacated the home following the district court summary proceedings. She left her home prior to contacting a fair housing center and retaining counsel. On the emotional support animal, the tenant actually removed the emotional support animal from the unit. And due to her emotional distress, her appointments with her therapist doubled. So she really needed the assistance of the support animal. Then the complaint was filed in federal court. Again, because she removed her emotional support animal, the landlord never filed against her in court. So as a result, right, the complaint was filed in federal court directly against the landlord, the mobile home park, and the landlord's insurance company under the Fair Housing Act and our state civil rights statute, Persons with Disabilities, Civil Rights Act, protecting persons with disabilities. Then liability was supported by HUD's recent guidance for assistance animals. HUD has it now in the 2020 assistance animal guidance. At this time, this case was filed. The 2013 guidance was still in effect. But basically, HUD's been consistent that breed and weight restrictions do not apply to assistance animals. They just hadn't looked at the guidance. The insurance company hadn't looked at the guidance, hadn't followed current standards under the Fair Housing Act. So the case settled with a $40,000 monetary payment. $20,000 came from the landlord and $20,000 from the insurance company. Actually, all 40 came from the insurance company because the insurance company paid the $20,000 for the landlord. The tenant was permitted to have her assistance animal in the unit. We're going to see the animal in a second. The insurance company agreed to change the policy so that breed weight restrictions would not be applied to assistance animals and to train its staff on the revised policy. And here's a copy. This came from the attorney for the defendant, basically said you can have your emotional support animal back in the unit, confirming, and the case has then been settled. So it's a lot, right? There are a lot of procedural barriers. It's sad to read the number of eviction cases where parties or tenants in eviction cases either failed to raise fair housing claims, or when they raised them, they lost them due to procedural barriers and not sure how to navigate the process of filing and pursuing fair housing claims in the midst of eviction proceedings. So the answer is keep the fair housing claims out of eviction court, wrongful detainer action, whatever. Put those in the court of higher jurisdiction. The best approach, if you possibly can, is to file in federal court before the state court proceedings are initiated. Also, pursue parallel proceedings. Pursue parallel proceedings with HUD or the Michigan Department of Civil Rights or your state and local agency. That can be a very, very helpful source of evidence. And it can give good rise to certainly punitive damages, because it's going to show that the housing provider landlord knew the requirements of the fair housing laws. Just real short, our mission, Fair Housing Center, sure equal access to housing without discrimination. Free, meaning free, nothing is charged. Individuals filing fair housing complaints were grant funded. Thank you, HUD, in state, our counties, city partners as well. So we can provide our services free of charge. We provide fair housing training, outreach, and education, and research in the area of housing. Our contact information is 313-579-FAIR and fairhousingdetroit.org. I want to, sorry about that. If you have other questions that you'd like to put in the chat, please feel free to do so. Sandra, the webinar started at 9. I thought it starting at 10. I don't know. It started at 10 Detroit time. You might be in a different time zone. I am so sorry. I will put the full webinar and PowerPoint on YouTube. Okay, so